Hello, and thank you for watching. This is Group 6, and this is our third assignment. Our research topic is the medical rights of teenagers and whether or not they should be allowed to refuse medical treatments. Again, our group topic, medical rights of teenagers. Should teenagers be allowed to refuse medical treatment? Assessing teenagers' right to refuse medical treatment poses challenges to both medical ethics and social policies. Our thesis statement states, even though some believe the right to refuse medical treatments is a natural human right, teenagers should not be allowed to refuse medical treatment because their lack of maturity and inexperienced judgments could lead to decisions with negative impacts financially and emotionally on the family and stretching the laws of medical rights. Subject headings and supported positions. My name is Cheyenne Wallace, and my subtopic was on the maturity level and inexperienced judgment of teenagers.
My name's Jade Hewitt, and my topic was emotional and financial costs.
My name is Jason McGrath, and I did the legality issues concerning the medical rights of teenagers.
And my name is Tegan Flynn, and I did the rebuttal and opposing views.
Hi, this is Cheyenne Wallace. My subtopic again was on the maturity level and inexperience of teenagers. And my first claim was regarding the maturity level of teenagers. As defined in the Merriam-Webster dictionary, an adult refers to a person who is fully developed and mature. So when you think of an individual between the ages of 13 and 19 years of age, labeled as a teenager, you really don't think of adjectives such as mature and fully developed. Those are far from mind. There are many laws that simply restrict individuals of that age from actions or making decisions best made by more experienced and competent individuals. Adolescents simply do not hold the legal status of an adult and are unable to sign binding contracts, unable to buy alcohol, marry without parental consent, and they must go to school. When considering maturity, an individual's age cannot simply be considered just because a 14-year-old could be mentally beyond their years, or you could have an 18-year-old who could lack the reasoning ability and social skills. An adolescent's psychosocial maturity can be measured by impulsivity, risk perception, sensation seeking, future orientation, and resistance to peer influence, which of course all of these things develop later than basic intellectual ability. When you consider a teenager's lack of judgment, legally, adolescents lack the general knowledge and experience to make decisions pertaining to healthcare, education, upbringing, leaving all of this responsibility to their parents. Though a teenager may be able to explain the reasoning behind a decision, they generally lack the emotional maturity to comprehend the deeper complexity of a decision. According to the U.S. Supreme Court, children lack the competency and it is required to seek parental consent before initiating treatments. And then when you look at the effects of puberty, mentally, emotionally, and physically, during this stage, adolescent's body goes through changes which can become uncomfortable and unstable. Also, adolescence is an important stage of growth. Teenagers' thoughts and actions can be unstable and one-dimensional. Researchers using MRI technology have discovered that an adolescent's frontal lobe, which controls decision-making, controls impulses, making moral judgment, assessing risk, they are generally less developed than that of an adult. In conclusion, teenagers are considered to be the responsibility of the parent and or guardian presiding, yet there are many who argue that they should be treated as adults and allowed to refuse or accept medical treatment. Due to a teenager's mind and body being underdeveloped, lacking experience and moral judgment, and undergoing emotional and physical changes, teenagers should not be allowed to refuse medical treatments without parental consent. And now we will hear from Jade Hewitt.
So my topic for emotional and financial costs. My first subtopic was parents who make the decisions for their children show more regret for their choices as well as emotional stress. As you can see in Figure 1, parents who make an informed medical decision for their children face greater regret and emotional stress. Also, parents who withdraw their medical rights and allow a physician to take their choices face less emotional stress and regret from the decision. After this decision is made to withdraw treatment, those who choose it are the most regretful. As you can see in my figure, it compares uninformed non-choices, which means those who were not informed about their child's death and had no choice in the matter. Informed non-choice, which is where the parents chose not to make the choice and let the physician choose for them, and then informed choice, which is where the parents chose to withdraw treatment on their own. As you can see, those who made the choices had the lowest ratings in preference for autonomy, decision confidence, and emotional responses. And my second key was the financial cost, and my claim was the percentage of Medicare and uninsured for the younger age groups would go down. It is estimated that there are more people with financial burdens for health care that exceed 10% of their family income than there are people who are uninsured. There are nearly 19 million people bearing burdens in excess of 20% of their family income. As you can see in Figure 2, Medicare is most spent in age groups 18 to 35. Also in ages 25 to 35 has the largest population of uninsured. So to conclude my topic, I believe that if children are given the chance to make their own medical choices, then they can spare their parents financial and emotional burdens. And now on to Jason with legal issues.
My name is Jason McGrath, and I have done the research regarding the legality issues concerning adolescents and their medical rights. For my first claim, I believe due to the lack of maturity and life experience, adolescents should not be allowed to make their own medical decisions. The legal rights concerning adolescents making their own health decision is dealt with usually on a state-to-state level. Most states will allow adolescents to make their own decision regarding contraceptive care without consent of an adult. On to the second slide. This figure shows data regarding the health care coverage among adolescents. Most health care for adolescents are covered under the private insurance that is usually obtained by their parents. As you see, the next largest is 33%, which is Medicaid coverage for adolescents. And then 7% is among adolescents are uninsured, and 3% are other. For my second claim, under the HIPAA privacy rule, adults are allowed access to their child's medical record as long as it does not interfere with state or other laws. Adolescents are less likely to seek help with substance abuse or mental health if their parents are aware. This is why I believe parents should be allowed to have access to their child's records to ensure that they will receive the proper help needed. And for my closing statement, arguments, I believe adolescents do not have the life experience or knowledge to make an educated decision regarding their own health or treatments that might be needed. This is why one of my many reasons I believe laws should not be passed restricting the rights of parents. And on to Tegan Flynn.
All right. So a teenager's right to refuse or seek medical treatment gives rise to conflicts in both medical ethics as well as social policy. And even though the law does not recognize teenagers as adults until they are 18 years old, many teenagers are known to be capable and responsible for making decisions regarding their own well-being. There are a few factors and specific conditions that allow teenagers the right to refuse medical treatment without parental consent. These include the mature minor doctrine, medical emancipation, and condition-specific circumstances. The mature minor rule or doctrine was created and implemented to appease the growing ethical sense that older teenagers have the mental capacity and ability to be their own medical decision makers. And according to Dr. Coleman, the idea that a 17-year-old is less cognitively capable than an 18-year-old to make their own medical decisions is recognized by the medical community as pretty much nonsense. While the rule is progressive and believed to be widely applied, it is not. The power to apply the rule is given to the states, and less than 1/5 of the states in the U.S. have the mature minor exception in general medical procedures to the standard parental consent requirement. My first figure is an example of a physician evaluation status examination pertinent to children competence. A judge in the court can seek to establish maturity of a minor by analyzing and evaluating the characteristics mentioned in the evaluation shown in Figure 1. Figure 2 shows the only states that have established legislation regarding minor rights and medical treatment. Of our 50 states, only 17 have mature minor legislation, and of those 17, only 14 have laws pertaining to the consent of general medical treatment, given restricted circumstances. 3 of those states allow minors, regardless of age or maturity, consent to refuse or seek medical treatment without parental or guardian knowledge or consent. The next condition that allows minors to give consent or refuse medical treatment is the emancipated minor rule. The emancipated minor legislation differs state to state, as well as the mature minor doctrine. The statutes that are known as the minor consent statutes or medical emancipation, they authorize minors to consent to care based on either their status or on the specific service they are seeking. The categories of minors that are authorized to consent or refuse medical care are as followed. Married minors, minors in the armed forces, mature minors are those who qualify recognition under the mature minor doctrine, minors living apart from their parents if they are older than 13, high school graduates, pregnant minors, or minors with children. Those who are included under these circumstances fall into these categories due to the idea behind it, which is because these minors are no longer under effective parental supervision. Parental consent is not a sensible precondition to assessing their care. The third and final circumstance that is considered when determining a minor's right to medical consent or refusal is condition-specific situations. There are many health services that do not require parental consent and for which any minor can give or refuse consented treatment. These services include emergency care, prenatal care, contraceptive services, abortion, diagnosis or treatment of venereal or sexual transmitted disease, diagnosis of treatment of reportable, infectious, contagious, or communicable diseases, HIVs or AIDS testing or treatment, and counseling or treatment for drug or alcohol-related problems, as well as in or outpatient mental health services. Many teenagers are embarrassed or scared to seek help from parents in these situations, which can be harmful or detrimental to their health. The purpose of the condition-specific situations is to protect the privacy and health of teenagers who otherwise wouldn't seek medical treatment. While the laws aim to protect minors' privacy and well-being, they only apply to certain conditions and variables, which leads to confusion and misunderstanding of minors' rights. In conclusion, regardless of the legal recognition of teenagers, anybody should be able to have some say in their medical treatment, and communication between teenagers and parents is crucial for their well-being and mental health and everything. And that's my conclusion.
Okay, thank you for watching Group 6's third assignment, subtopic medical rights of youth and whether or not they should be allowed to refuse medical treatments. Thank you.